We were one huge military base of the Americans. When the Japanese came, well, it was good that Churchill called the Filipino soldier as the finest warrior in the world. Kasi in the end, ang kailangan dyan, puso eh. Puso ng Vietnamese, tinalo ang Pranses, tinalo ang Kano. So, I agree with Lord Palmerston. A country has no permanent friends, no permanent enemies, only permanent interest. I happen to have seen, again, Pearl Harbor kahapon. Colonel Doolittle read that raid in Tokyo on April 18, 1942. And after the successful raid, they ran out of fuel. Saan pumunta? At China, where they were protected by the Chinese. Kaya dito po, ang main point lang ho natin, kung hindi natin pagpipitaganan ng ating sariling saligang batas, who else will? Kalilinaw ho sa Section 21 of Article 7 and Article 18, Section 25, na no foreign troops or facilities can be reinstalled here without the concurrence of the Senate, which has an exalted role in foreign relations shared with the President. Kaya dito, kung hanggang hindi ipapasa sa inyo, I hope it will be in some kind of suspended animation until Mr. Aquino is persuaded to follow the constitutional, institutional arrangement. Yun din hong duration, may automaticity. 10 years, unless repudiated, it can go on and on. Kaya yung apo ko hong 6 na taon lang, mahilig magsundalo, may be involved in that shooting war. And that is why it cannot be decided by one man alone with one or two others. Nung panahon namin dito, the one who dealt with us, Secretary Manglapus, a former colleague, a lawyer, there was transparency and there was involvement. Hindi lang pinalagay ng Malacanang na silang lang ho ang mga anak ng Diyos. Yun ho ang nangyayari dito eh. My good friends, Mr. Aquino, Mr. Gasmin, they should involve those of us who would really feel the consequences. Ako ho, medyo last quarter na, last 2 minutes, baka nga ho nasa pre-departure area na. But I care for my apos. I want them to have a say. Dito, sa puwera kayong madlang people, kami lang ang mga anak ng Diyos. Yun ho ang dating nito eh. I regret to have to differ with my good friend, the President, who I support maybe 99% of the way, but not here. His own mother called Senator Butch Aquino and me in 1991 to ask for our vote. And we told her gently, please ask us another. Dito din ho, pinatawag kami ng anak ng July 1, kami ni Senator Bobby Tanyada, and same thing, we said, you may not ignore the Senate. Pero ang lumabas ho, Diario, huwag nyo nang pansinin yung dalawang matandang yun. Baka interviewin nyo pa yun, etc. Yun nga ho, pagpitagana naman kaming medyo last 2 minutes, o pre-departure area na ho, because as you may recall, I once worked here, and I was very proud of our Senate, which was not ignored by his mother. Kaya dito ho, ang pakiusap ko sa inyo, siguro please pass a sense of the Senate resolution na in this matter, the Senate may not be ignored. Maraming salamat po.
Thank you, Senator Sagisag. If there are no other questions, we'll call on Solicitor General. after him, we will call on Attorney Harry Roque.
Madam Chair of the Senate Foreign Relations Committee, Honorable Senator Miriam Defensor Santiago, Senator Pia Cayetano, Senator Ferdinand Marcos Jr., good morning. We consider it a privilege to be invited to this morning's session on matters relating to the Enhanced Defense Cooperation Agreement between the Republic of the Philippines and the United States. In order to assist this honorable committee, if I may, I would like to focus my statement on the constitutional law aspects of the EDCA, especially those that were discussed in last week's oral arguments before the Supreme Court. In particular, we would like to restate the government's position on the nature of the EDCA as an executive agreement. The characterization of the EDCA as an executive agreement rests on the concept that the President has the authority to enter into implementing agreements pursuant to existing treaties. For purposes of comparison, allow me to point out that the United States recognizes 4 different types of international agreements. The first is the treaty, which is an international agreement entered into by the President with the advice and consent of the Senate. The second is the Congressional Executive Agreement, which is an international agreement entered into by the President with the approval and authorization of the entire Congress. The third is the Executive Agreement, which is an international agreement entered into by the President to implement a treaty. This is the overwhelming number of agreements entered into by the United States President. The fourth is the sole executive agreement, which is an international agreement entered into by the President on his own authority. With the exception of congressional executive agreements, Philippine practice coincides with these categories of international agreements. This practice is found in Executive Order number 459, providing for the guidelines in the negotiation of international agreements and its ratification. The power of the Philippine President to enter into executive agreements to implement existing treaties also finds support in jurisprudence. For example, in the often cited case of Commissioner of Customs versus Eastern Sea Trading, which describes executive agreement as adjustments of detail carrying out well-established policies. Executive agreements are also explicitly recognized in our present Constitution. In Article 8, Section 5, Paragraph 2A, which gives the Supreme Court jurisdiction over, quote, all cases in which the constitutionality or validity of a treaty, international or executive agreement is in question, unquote. There's a reason why executive agreements are not found in Article 8, or are found in Article 8, not in Article 7, and that is because only treaties and international agreements need concurrence. Executive agreements found in Article 8 need no concurrence. One may ask, in particular reference to the EDCA, what does this executive agreement implement? The answer, Madam Chair, is that the EDCA implements the Mutual Defense Treaty of 1951 and the Visiting Forces Agreement of 1998. The MDT has 2 important operative principles. The first is the principle of defensive reaction in Article 4, which involves assistance in the case of an armed attack on either of the parties in the Pacific area. The second is the principle of defensive preparation in Article 2. It states that in order more effectively to achieve the objective of this treaty, the parties separately and jointly, by self-help and mutual aid, will maintain and develop their individual and collective capacity to resist armed attack. On the other hand, the Visiting Forces Agreement, another treaty, specifically allows into our territory the presence of U.S. troops and personnel, equipment, materials, supplies, other property, vessels, and aircraft. It is the position of the President as Commander-in-Chief, Chief Executive, and Chief Architect of Foreign Relations that the principle of defensive preparation in the NDT and the Visiting Forces Agreement constitute the totality of the licenses and authorizations needed for the President to enter into the EDCA as an executive agreement. In material terms, what this means is that insofar as the presence of U.S. troops, personnel, equipment, materials, supplies, vessels, aircraft are concerned, the license has already been secured through the VFA. On the other hand, insofar as improvements and infrastructure works on Philippine military bases and facilities are concerned, the license has already been secured through the MDT. A significant aspect of the Philippines' objective of establishing minimum credible defense is the improvement of our runways, barracks, ports, and hangars. These infrastructure improvements on Philippine military bases and facilities jibe perfectly with the MDT's concept of defensive preparation. It is therefore consistent with the MDT's defensive cooperation principle to allow the U.S. to assist the Philippine government in the improvement of Philippine military bases and Philippine military facilities. There are some who argue that the EDCA is a treaty and that it cannot be couched as an executive agreement because it allegedly allows foreign military bases and foreign military facilities. First, Article 5 of the EDCA clearly states that the Philippines shall retain ownership of and title to the agreed locations. And so by clear consequence of law, these locations are not a situs of extraterritoriality. They are Philippine territory and Philippine property. Second, the United States may be permitted by the Philippines to construct and improve infrastructure in these locations. The United States, however, will not be building in the concept of an owner. They will be building for the Philippines. This is because under the EDCA, quote, all buildings, non-relocatable structures, and assemblies affixed to the land in the agreed locations, including ones altered or improved by U.S. forces, remain property of the Philippines, unquote. Third, the use and access of Philippine military bases will be restricted and consistent with our national security interests for the following reasons. Number one, such use and access will be for activities that must be approved by the Philippines. No prior approval, no access and use of areas and facilities. Number two, such use and access must be on a rotational basis, intermittent and temporary. Number three, the government shall have access to the entire area of the locations. Number four, the government shall retain primary responsibility for security with respect to the agreed locations. Number five, operational control of the United States is limited to construction activities. Number six, the agreed locations will be areas of joint use, consistent with the concept of responsibility based on proportionate use of the areas and facilities as stated in the EDCA. These indicators are sufficient to make a reasonable person conclude that the agreed locations are not, will not, and cannot be converted into foreign military bases or foreign military facilities. The general features of foreign military bases, extraterritoriality, exclusivity in use, and foreign ownership, are not present in these locations. And so by their design or function, or by the standards of ownership, control, and use, these agreed locations cannot be considered foreign military bases or foreign military facilities. They are simply Philippine military bases. We consider the defining characteristic of foreign military base the general ability of the foreign force to define, within the base, the nature and the scope of the activities they wish to engage in. This plenary ability, this general purpose license, is found only in the former Military Bases Agreement of 1947, which gave the United States, quote, the rights, power, authority within the bases, which are necessary for the establishment, use, operation, and defense thereof, or appropriate for the control thereof, and all the rights, power, and authority within the limits of territorial waters and airspace adjacent to, or in the vicinity of the bases, which are necessary to provide access to them, or appropriate for their control." Unquote. This plenary ability, this general purpose license, is patently and demonstrably absent in the EDCA because of the permission system in place for every activity that will be undertaken by the U.S. forces on Philippine soil as already mandated by the Visiting Forces Agreement. The Philippines has control over these locations not only because we own them, but also because we can set the parameters for their use and access by the United States through the permission system that is in place. By this control test, the agreed locations are decidedly Philippine, not foreign military bases. To conclude, the EDCA is an executive agreement because it implements the principle of defensive preparation and cooperation under the MDT and the specific rules of the VFA with respect to the presence of troops, equipment, supplies, vessels, and aircraft. In the view of the President, all the necessary licenses for entering into the EDCA have already been secured. It does not involve foreign military bases. It involves the improvement of Philippine military bases. Thank you, Madam Chair, Senators. We hope that this short presentation has been of some assistance to the Honorable Committee.
A lot of assistance. The question is this. The Constitution prohibits foreign military bases, troops, and facilities unless the Senate has concurred. Ngayon ang EDCA, hindi binigay sa amin for concurrence. Bakit hindi ba siya base? Hindi ba siya troops? Hindi ba siya facilities? Kung hindi man siya, ano siya?
Maraming salamat po. Insofar as the EDCA is concerned, Madam Chair, yung pong presence ng troops has already been allowed under the VFA. And so to the extent that the EDCA allows the presence of troops, it is derivative of the VFA. In the matter of foreign military bases and foreign military facilities, Your Honor, Madam Chair, the position of the government, and we have given you the various tests that are available, is that this does not involve the presence of foreign military bases or facilities. This involves the improvement of Philippine military bases and facilities. And so we have ownership, we have control, we have access, but we will allow them operational control for construction activities, which is only reasonable, Your Honor, because they're spending their funds for purposes of construction of runways, ports, hangars, and barracks.
You proposed several tests to determine whether the so-called agreed locations, which is actually a euphemism for foreign military bases, or at the very least foreign facilities, you argued that agreed locations are different from a foreign military base or facilities. But you forgot to apply the test of geography, the most basic test of all. Saan ba itong mga foreign military bases, troops, and facilities ng Amerika nandito ba sa atin o doon sa kanila? Ba't nila ilagay doon sa sarili nila? Ba't kailangan na sa atin? With the globalization of warfare today, they can very well defend themselves from their own homeland. Why do they have to use ours? That's the basic question. Kaya, hindi ba yan patunay na tayo kasama lamang sa sinatawag nilang strategic guidance? Strategic guidance is a little book that tells us what the Americans want to do militarily in the near future. Ang nakasabi doon na gusto lang nila, nakasali rin ang Pilipinas sa kanilang mga allied states, kamukha ng Singapore at Australia, na tayo isang grupo na leader natin ng Amerika para kung ano man ang kinagalit ng China, tayo munang tatamaan, hindi sila. Oh, pakisagot mo lang. What about geography? What about the test of geography?
Thank you, Madam Chair. Our position, Your Honor, is that these agreed locations are so-called agreed locations, primarily because the Philippines will have and the United States will have to agree with respect to the locations of these premises. And these premises will necessarily have to be Philippine military premises because under the EDCA, it is only Philippine military premises that can be determined as agreed locations. While it is true, Your Honor, that the United States has its own independent interest in coming over here, the position of the Philippine government is that there is a convergence of interests here. Of course, the United States would like to exert its might and project its force within Asia, but we in the Philippines, Your Honor, have our own, independent and more parochial concern, which is modernizing the Philippine military forces, taking and we'd like to take advantage of the interests of the United States so that we can improve our own facilities.
Thank you. Are there questions
Thank you.
from our panel? Senator Marcos.
Thank you, Madam Chair. We've heard a lot this morning about the improvement of our capabilities, the improvement of our readiness, and it has been proposed that that is the main purpose of the agreed locations to improve our maritime security, to help in the organization of our military exercises together with the United States. However, in Article 6 of the agreement of EDCA, it speaks mostly of prepositioning. And prepositioning, I take to mean, is simply the forward positioning of material so that when there is a deployment in that part of the world, that this material need not come from a distance far away in the United States. I am reminded of the prepositioned material that you see in a place like Hawaii, where there are acres and acres of military equipment just waiting to be deployed should there be a need. And furthermore, it is in paragraph 3 of Article 4, it reads, the prepositioned material of United States force shall be for the exclusive use of the United States force, and full title, such equipment, supplies, and material remains with the United States. The United States will have control over the access to and disposition of such prepositioned material, and shall have the unencumbered right to remove such prepositioned material at any time from the territory of the Philippines. This is implying that this prepositioned material in the Philippines agreed locations is for war. And it is not to do with training, it is not to do with increasing the Philippine Armed Forces capability, but merely it is using the agreed locations in the Philippines should there be a need to prosecute a war in our part of the world, which will and the prepositioning of this material will be clearly for the use only of United States forces. Surely, that implies that this is now a U.S. base. Soljan or Yusek Batino?
Thank you, Madam Chair and Your Honor. We would like to make emphasis on the pertinent phrase in paragraph 1 of Article 4 that requires the prepositioning of and storing of defense equipment to go through bilateral security mechanisms, such as the Mutual Defense Board and the Security Engagement Board. This clearly provides that the Philippines' consent is needed for the prepositioning of this material, taking into consideration our own national interests.
My reading will have to be, I beg to differ. My reading of it is that it does not require the Philippines consent any longer, because in the language, Philippine consent is actually being given. And therefore, that consent need not be given at any time in the future. It is already given by virtue of this agreement. So there is no bilateral consultation in any way. Dahil binigyan na natin ng karapatan na sige, magpasok kayo ng kung ano yung gusto ninyo. Na mailagay ninyo dito sa mga agreed location, mga gamit na hindi naman magagamit ng mga sundalong Pinoy. So, paano hindi naging base yan? Parang it looks to me, it sounds a lot to me like a base, because this is precisely the kind of activities that they do on bases on American soil. Kaya nga, hindi napapag-usapan natin na maraming nababanggit tungkol nga sa training, capability, disaster relief, okay, lahat yan. Pero maliwanag na maliwanag, meron silang may bahagi nung agreed location na para sa Amerikano lang. At tayo naman ay pumayag.
Yes, Your Honor. We think that we need to contextualize the language presented under paragraph 1. The Mutual Defense Board and the Security Engagement Board are established consulting mechanisms that meet regularly, year to year, to discuss the activities and all other details in connection with these activities. Thus, this is a regular consulting mechanism between the U.S. and the Philippines in the planning of training activities, as well as other operational details such as venue of the training exercise and the possible material to be used for the training exercises. So it is our position, Your Honor, that through paragraph 1, it is clear that there is still this consenting mechanism that is needed to be passed before any preposition material could be decided by the two parties to be stored in the agreed locations.
Well, again, the last paragraph of the last sentence in that paragraph says, the United States forces shall notify the AFP. Will not consult, will not seek the agreement, but will notify. Again, this bilateral consultation seems to be absent in that kind of language.
Your Honor, the first sentence would pertain to the identification of the preposition material to be stored. Once that determination has been made, then we still require the U.S. to notify us in advance of the delivery of these preposition material. Of course, this is needed so that we could coordinate our protocols with the delivery of these items. Also, Your Honor, we would want to also emphasize a very important paragraph in Article 4, specifically paragraph 2, where the parties share a recognition of the benefits that such prepositioning could have for HADR and for the enhancement of their individual and collective defense capabilities, which is again in consonance with Article 1 of the EDCA, which focuses on the development and preparation of our individual and collective capacity for mutual defense. We note, Your Honor, your observation under paragraph 3. And it is our position that this is a reasonable provision because these equipment and material stored really still belongs to the U.S. However, it will be used for the conduct of training exercises for the benefit of both the Philippine and U.S. forces. It can be used for HADR in times of disasters.
But you said there's nothing here to say that the preposition material will only be relief goods, will only be water supply for disaster preparedness, will only be for that. If that were the only thing, that certainly wouldn't be a problem. But we are talking about weapons and material that are being stored. But anyway, I need not belabor the point. I think I have made my point that it should seem that at the very least, there is a section, a part of these agreed locations, which will be for the sole use of the United States forces, which would seem to imply that they have now established a base in the Philippines. So with that, Madam Chair, thank you.
Attorney Harry Roque.
Good afternoon, Madam Chair. Good afternoon, Senators Marcos and Senator Cayetano. I will not repeat points previously discussed by Dean Magaliola and the chairperson as well. I will, however, focus on 3 points. Number one, that this EDCA cannot be an implementation of the MDT, nor can it be an implementation of the VFA. Secondly, why, for all intents and purposes, the provisions of EDCA provides for the establishment of military bases. And a third point I'd like to address is whether or not the exchange of ratification has made EDCA already effective under the Vienna Convention on the Law of Treaties. Now, it is our position that EDCA cannot be an implementing agreement on the Mutual Defense Treaty because, number one, it constitutes a new policy. Number two, it has a different object and purpose than the MDT, and it has a different context from the MDT. Now, we say that it is a new policy because it forms part of literally a brand new policy. No? And according to the decision of the Supreme Court in Commissioner versus Eastern Trading, treaties that formulate a new national policy need the concurrence of the Senate, and those that merely restate existing ones don't need the concurrence of Senate. Why do we say it's a new policy? Well, it's a new policy that makes the Philippines a partner of the United States in its brand new defense policy. Now, under this new strategic guidance, which has been mentioned by the chair and the Magaliona, not only is there a pivot to Asia, but they will now emphasize existing alliances and expand networks of cooperation. Now, according to former President George Bush, the U.S. must be ready to strike at a moment's notice in any dark corner of the world. And this new policy was really summarized by a quadriennial defense review, which says that they must move away from obsolete Cold War garrisons, such as permanent bases, to mobile expeditionary operations. Now, under this new setup, the United States will maintain 3 kinds of U.S. military facilities. They will maintain military structures, those in Germany, in Guam, and in Korea. They will soon be kicked out of Japan. Secondly, they will have what they call forward operating sites. Now, these are still owned by the U.S., but they're smaller. There are more space bases that could be expanded when there's a need for it. They will have pre-positioned equipment and will also host a small number of troops on a rotational basis. A third type is one which includes EDCA. It is called the Cooperative Security Locations. They are facilities owned by host governments to be used by the United States in case of actual U.S. operations. I emphasize actual U.S. operations. But meanwhile, they could be visited and inspected by the United States. They will be useful for pre-positioning logistic support or as venues for joint operations with host militaries. They could also be expanded into forward operating stations. Now, the problem is the executive, by merely restating Article 2 of the Mutual Defense Treaty, believes that it has become a mere implementing agreement of the MDT. Of course, this is not in accord with the rule of interpretation of treaties in the Vienna Convention on the Law of Treaties. No? Not only must we interpret treaties in good faith using their ordinary meaning, we must also do so in their context and in light of its object and purpose. Now, clearly, the object of the MDT is specified in Article 4 of that treaty. When one party is attacked, the other would consider that to be dangerous to its own safety and they will act to meet the common dangers in accordance with its constitutional processes. So any response cannot be swift. It must pass through their constitutional processes, and in the case of the United States, through the U.S. Congress for declaration of war. Now, Article 5 in turn defines what the objects of attack that could trigger the application of the treaty, and that includes an attack on either of their metropolitan territory or on either of their island territories under its jurisdiction in the Pacific. Now, obviously, the EDCA cannot be a mere implementing agreement of MDT, assuming even that MDT is valid despite the objections raised by Dean Magallona, because the EDCA is not just for the purpose of collective security. There is no restriction on what the Americans can do, and because of this, the Americans can even use our military bases for the purposes of committing the crime of aggression. They could even use our military facilities for rendition, and this is not fiction. In Arar versus Ashcroft, the Canadian government awarded damages to a Canadian national who was mistakenly rendered to Syria and tortured, after he was intercepted by the CIA in JFK in New York. And they could even use it as operation for flying of drones, which already a high court in Peshawar said was illegal under international law because it violated human rights and international humanitarian law. The Human Rights Council only last week decided to form a body precisely to rule on the legality of these drones. Now, the context is also different. Dean Magallona already mentioned that the context is the Cold War. And in fact, the premise was that an attack on the Philippines was an attack on the U.S. since the U.S. had their biggest naval and Air Force bases in the country outside of continental United States. Of course, today, matters have changed. Not only is there firm diplomatic relations between the U.S. and China, the USSR has become a thing of the past. China has become the biggest creditor of America, the biggest foreign investor in America, and SEATO, which was the regional collective organization established to complement the MDT, no longer exists. Now, here are some of the textual differences between EDCA and the Mutual Defense Treaty, in addition to the fact that they have different object and purpose. Number one, there is no such thing as rotational presence of troops under the MDT. And the reason for this is that the presence of troops during those times was pursuant to the Military Bases Agreement. And that's why the MDT does not talk at all about the stationing of troops, bases, and facilities into the country. Number two, well, it's very clear that pursuant to the new U.S. policy, EDCA forms part of an actual defense operations and not just for preparedness. It's not just for purposes of developing capacity to exercise self-collective defense. Number two, even in the Military Bases Agreement, we did not give contractors such as Blackwater the status as if they form part of U.S. forces. They are now considered as part of U.S. forces. Now, in Iraq, there's lots of legal controversies generated by Blackwater because Blackwater seem to be invoking the same kind of immunities that the U.S. government can invoke where there are complaints that they have violated international humanitarian law. Now, moreover, the presence of troops, bases, and facilities in the EDCA is really more akin to the Military Bases Agreement, which was rejected in 1991. They're so expansive and sovereign powers are so expansive that I will discuss this in a while, to show why we believe that there is actual basing. Now, as far as facilities, of course, there's no prepositioning of equipment under the MDT. And again, highlighting the fact that EDCA authorizes their use for other than collective security purposes, even if it has no relation to the Philippines whatsoever. And this is one peculiar fact under EDCA, The Americans are allowed to operate their own telecommunication facilities, which under the Constitution is reserved to Filipinos and must be provided a franchise by Congress, but we have given it to the Americans hook, line, and sinker. Now, why do we say that it is also not an implementation of the VFA? Well, very clearly, Madam Chair, Your Honors, this Congress in Senate Resolution number 16, which provided its concurrence to the VFA, made it very clear that the presence of the United States troops and facilities under the VFA should only be for visit and for joint military exercises. Obviously, this is not the case with EDSA because the Americans can use their troops and their prepositioned equipment for actual U.S. defense operations. Another difference, of course, is there's no prepositioned equipment under the VFA, and there are powers provided under EDCA which are not found in the VFA. And I quote actually from the very primer published by the DFA in this regard, no? Because other than visiting and joint military exercises under EDCA, they are allowed to build temporary accommodation, prepositioning of equipment and materials, as well as deploy force and materials. Now, likewise, this is very important, Your Honor. The VFA rules on jurisdiction, including primary Philippine jurisdiction for non-service related offenses, apply only when the VFA is applicable. When U.S. troops are here for visit and joint military exercises. When they commit a crime, similar to what Nicole experienced and what Jennifer Loud experienced, rape and murder, and the troops are here because of EDCA, the rules on jurisdiction over the servicemen will not apply. Instead, it is the general rules of customary international law that will apply, and that is complete immunity from domestic jurisdiction. That is very clear because EDCA goes beyond visiting and joint military exercises. Now, why do we say also that this provides for permanent bases? Although I highlight that what the Constitution prohibits in Section 25 of Article 18 is not just permanent bases. It could include temporary bases because the language of the Constitution is unqualified. Troops, bases, and facilities. No? Here are specific provisions. Number one, the term. It could be a lifetime, which is similar to MDT. Number two, it is incorrect, I believe, to invoke that it is not a base because there is no extraterritoriality. The concept of extraterritoriality has been abandoned. That was the ruling in the Lotus. Today we talk only of immunity from domestic jurisdiction. We no longer consider foreign ships as floating territories. We no longer consider diplomatic premises as foreign soil in Philippine territory. They remain Philippine territory but exempt and immune from domestic jurisdiction. So it does not matter that there is no extraterritoriality because what is important now in international law is whether or not they're immune from domestic jurisdiction. And I believe they are. Number one, under the paragraphs, no, you can see that U.S. personnel, property, equipment shall be allowed to operate in agreed locations. They shall have access and use. Next, not only access and use, they will also have access to public land and facilities, including those owned by local government and other land and facilities. They can use the entire Philippines as a military base for what they want. And of course, although they say that there is no extraterritorial application, look at this provision. Philippine authorities required to comply with operational safety and security requirements for them to have access to agreed locations. Ibig sabihin po, bagamat nakasabi doon na bawal ang nuclear weapons, paano natin malalaman kung may nuclear weapons nga? Eh hindi naman tayo po pwede pumasok doon sa mga facilities nila unless we comply with quote-unquote safety, safety, operational safety and security requirements. Kapag nuclear weapons po yun, siyempre merong restricted, do not enter. So tapos na po ang usapan, hindi na natin ma-verify kung meron nga silang nuclear weapons. No? And then, yung prepositioning nga po, it is exclusive use of U.S. forces and full title remains with the U.S. Ang punto po dito, hindi na nila kailangan ng U.S. bases kasi they cannot afford it economically and politically. So they just want to use ours, but only for their sole benefit. Ito pa po yan, they shall retain title to all equipment. They may construct permanent buildings which shall be used by U.S. forces until no longer required. And the absurdity of this is while they are here rent-free, if we want these facilities, we have to pay a price for it. And finally, they have the right to use water, electricity, other public utilities, and to operate its own telecommunication systems. No? And the catch-all provision is, we gave U.S. forces authority to exercise all rights and authorities within agreed locations that are necessary for their operational control or defense. Where is the exercise of Philippine jurisdiction when we have given them blanket operational control or defense, and not just for construction purposes? My last point, Your Honor, is I was shocked that in the Supreme Court, the position of the executive was that this agreement was already in force. I do not think that just because the executive says it is in force, that in fact it is, because under the Vienna Convention and the law of treaties, there is only one exception where a state may invoke its domestic law as a ground for non-performance of a treaty. And that is when the consent is vitiated by reason of a domestic law requirement that is manifest, number one, and of fundamental importance. I believe that Section 25 of Article 18 is lex specialis because it applies only to exclusively to military bases, troops, and facilities, and that this is manifest because Americans knew this when this Senate rejected the basis agreement in 1991. And therefore, I think under international law, we can rightfully invoke that our consent was not properly given because the Senate was not asked for its concurrence to this EDCA. Thank you, Madam Chairman.
Thank you very much for that spirited presentation. Unfortunately, we're running out of time. The Senate plenary session will begin at 3 o'clock. In any event, we have the negotiating panel for EDCA here. They will be available to take any questions if necessary. And we shall hear possibly not the entire statements, but at least the crux of the statements from the remaining resource persons against EDCA. So I will call you in the order in which you are seated, Dr. Roland Simbulan, Secretary General Renato Reyes, and Representative Nery Colmenares. Dr. Simbulan, please.
Madam Chair, I respectfully thank the Foreign Relations Committee for inviting us, the Center for People Empowerment in Governance, or CENPEG, to give our views on the controversial Enhanced Defense Cooperation Agreement, or EDCA. CENPEG is a policy research and policy advocacy think tank on issues of governance, including Philippine foreign policy. I'm currently the Vice Chair of the Board of Directors, and I've authored several books on U.S. military bases, Philippine-U.S. relations, and U.S. military presence in Asia and the Pacific. Madam Chair, I will immediately address the 4 topics that you have identified to be discussed in this public hearing on EDCA. 1. Does EDCA need to be concurred by the Senate? The EDCA needs to be concurred by the Senate given the constitutional requirement that any treaty or international agreement that will allow foreign troops, foreign military facilities, and foreign military bases on Philippine soil should be submitted to the Senate to be concurred by 2/3 of its members. This provision is as clear as day, despite the fact that the proponents claim that it merely implements provisions of the mother treaties such as the 1951 Mutual Defense Treaty and the 1999 Visiting Forces Agreement. But how can EDCA be a mere implementing executive agreement when it includes specific new provisions that rightfully belong to a new treaty? We should not let this trick pass, for this may be used as a precedent for future controversial executive agreements, which in fact are new treaties on the grounds that they are mere implementing agreements of previous treaties. From the text of EDCA, as it has been made clear by our previous resource persons, it is clear that U.S. troops are to be deployed and U.S. military facilities will be constructed with the assistance of U.S. defense contractors inside Philippine military camps in any part of our country. From the provisions of EDCA, even the jurisdiction of national and international courts will have to be waived in relation to disputes arising from the implementation of EDCA. These are just some provisions among many others that rightfully belong to a new treaty that need the concurrence of the Senate. Number 2, is EDCA necessary? The EDCA enhances the revival of the Cold War in the region in the context of the United States-Asia pivot. The Cold War has long ended. Proponents of EDCA promote the usual misconception that U.S. forces will come to our rescue in the worst-case scenario should a shooting war over the Spratlys erupt between China and the Philippines. There is no guarantee for such U.S. support in either the MDT, the VFA, or the EDCA. For instance, in 1975, U.S. State Secretary Henry Kissinger clarified that the Spratlys are not included nor recognized by the United States as part of the coverage of, quote, the Philippine Metropolitan Territory as defined under the Mutual Defense Treaty. Gone are the days when small nations were used as pawns of the big military powers. So let us not allow this to happen again to us through EDCA. Trade and economic competition under the globalization regime has become the means for nations, even the big powers, in dealing with each other. Number 3, is EDCA beneficial? EDCA will only enhance the isolation of the Philippines from the fast-growing regional economic growth centers of Asia. We will forfeit our national interests if we focus on again allowing foreign military forces to be stationed on our territory and to use our territory again as a launching pad and springboard for U.S. interventionary wars. I recall, Madam Chair, that when I visited Vietnam's War Museum in Ho Chi Minh City only last year, a section of that museum mentions the Philippines as, and I quote, a satellite country of the United States, which not only sent, quote, mercenary troops paid by the United States to fight the Vietnamese people, but the museum mentions, and I quote, the Philippines allowed U.S. military forces at Clark Air Base and Subic Naval Base to launch bombing attacks and military blockades against the Vietnamese people, end of quote, who heroically resisted and eventually defeated U.S. military intervention in their country. Did we then realize that that situation jeopardized our security, as EDCA now jeopardizes it because of the enemies of the United States all over the world, which will target U.S. military forces, including in our country? Geographically, we are part of the regional growth center with ASEAN countries, China, Japan, and South Korea. EDCA will allow the unlimited prepositioning of U.S. troops, facilities, and war material in any part of the Philippines, rent-free at no cost to the United States. As a consequence, we will be dragged as an accessory to the United States' international conflicts, its wars of intervention, aggression against other countries who are not even our enemies. We will be abdicating from the fruits of this growth center in our region if we play into the hands of the U.S.-Asia pivot to remilitarize the region instead of focusing on trade, investments, and economic relations. And finally, to the question, is EDCA practical? The EDCA enhances U.S. intervention in the Philippines with the regular presence of foreign troops all year round, as they have been here since 2003, thus overturning this Senate's historic rejection of the U.S. Bases Treaty in 1991, and the Senate resolution in 2009, which called for the abrogation of the VFA, the basis of EDCA, should the U.S. refuse to a bilateral review of the VFA to amend its onerous provisions. And if the proponents of EDCA continue to insist that this is just a mere implementation of previous existing treaties, then by all means, let us abrogate the roots of these sellouts, the MDT and the VFA, which have transformed our country into a de facto forward base for U.S. interventionary forces of what the renowned American scholar Dr. Noam Chomsky calls, quote, the #1 terrorist state, end of quote, in the world today. The Philippine Constitution, we believe, incorporated the stringent requirement for this kind of agreement be submitted to the Senate for concurrence so that our nation will never again compromise our tenets of sovereignty, peace, and self-determination for ourselves and our neighbors by hosting foreign military forces such as those of the United States, which were used actively for aggression and intervention against smaller states and peoples seeking self-determination. Agreements like EDCA are patently one-sided or onerous, and it is a clear-cut case of negotiated subservience. So why do we agree to them and accept and inflict upon ourselves this kind of negotiated subservience? Madam Chair, even the Department of Foreign Affairs, in its note verbal to the U.S. Embassy, number 060103, dated January 17, 2006, on the implementation of the EDCA's Mother Treaty, the VFA, in connection with the issue of the custody of Daniel Smith, wrote, and I quote, "In addition, while aware of the differences between the agreement and similar agreements entered into by the United States, the Philippine government is seriously concerned over the patent disparity in the treatment of U.S. military personnel in other countries on the issue of custody in criminal cases." End of quote. So, what did we do about this? We inflicted on ourselves a graver form of subservience, the Enhanced Defense Cooperation Agreement. Sadista talaga tayo sa ating sarili. Thank you, Madam Chair, for this honor of inviting us to your committee to present our views on this controversial issue that needs to be addressed from the perspective of Philippine national interests and Philippine national security. Thank you and good afternoon.
And thank you too. Mr. Renato Reyes.
Next pa. Maraming salamat po. Magandang tanghali. Katulad din po ng mga nabanggit, no, hindi po maaaring ituring ang Mutual Defense Treaty bilang framework para sa pag-iistasyon ng mga sundalong Amerikano sa ating bansa. Katunayan po, bago pa man magkaroon ng Mutual Defense Treaty, may mga sundalong Amerikano nang nakabase sa ating bansa. At ito ay sa pamamagitan ng Military Bases Agreement of 1947. So it predates the Mutual Defense Treaty. Hindi rin po maaaring gamiting batayan ang VFA tulad rin ng nabanggit dahil nga po ito ay para lamang sa panandalian, temporary na pagdalaw ng mga sundalong Amerikano sa ating bayan. Pero sa mga nagdaang taon, nagawan po nilang paraan para ikutan yan dahil nga tinatawag na ngayon nilang rotational presence. Ibig sabihin, may papasok sa ating bansa, may lalabas, but at any given time, there will always be American troops in our country. Yet, we cannot use the VFA because the VFA does not allow the construction of permanent facilities for U.S. forces. Sa tanong po na, is EDCA necessary? We believe that EDCA is not necessary for the defense of Philippine sovereignty and the advancement of our national interest. The U.S. is part of the U.S. strategic pivot to Asia. Ito pong pivot, which was announced in 2011, was the reason why the Philippines and the U.S. held a meeting, yung 2+2 meeting in Washington, and there they approved a new policy, the policy of increased rotational presence. It was only after the policy of increased rotational presence was approved that negotiations for EDCA started. The original title of the agreement was the Framework Agreement for Increased Rotational Presence and Enhanced Defense Cooperation. So doon po malinaw, no, na ang nag-trigger ng EDCA ay yung announcement ng US sa kanyang pivot sa Asia, ang kanyang pagnanais na protektahan ang kanyang economic at military interest sa Asia. Next. At hindi po tayo ipagtatanggol ng Amerika sa ating mga usapin laban sa China. Wala pong nasasaad sa EDCA. Kaugnay niyan, wala ring nasasaad sa Mutual Defense Treaty. At kahit nga po, ang presidente ng Estados Unidos ay malinaw na nagsabi na wala silang intensyong makipaggera sa China. Next. So, usapin po ng is it beneficial? Ito po, marami pong ipinapangako sa atin ng Philippine government pero hindi po yan makakamit, no? Hindi po tutungo sa modernization ang EDCA, hindi po ito makakatulong sa AFP modernization. Walang sinasabi sa EDCA kung paano tayo magiging moderno sa pamamagitan ng war games, rotational deployment, o yung storage at prepositioning ng weapons and other forms of interaction with U.S. troops. The agreement does not say how the AFP will acquire X amount of weapons, ammunition, vehicles, vessels, and technology in exchange for the use of our facilities. Next. Hindi po talaga tayo makikinabang. Mas sila po ang makikinabang kasi nga po sa prepositioned material at yung pagbabase nila sa ating bansa. Ang kanilang mga kagamitan na nandito sa ilalim ng EDCA ay eksklusibo lamang para sa gamit ng mga Amerikanong sundalo and can be moved out of the country anytime. All relocatable or movable items owned by the U.S. forces will be brought back to the U.S., leaving us with only empty buildings. They can bring home literally everything, including the kitchen sink. So ano ang matitira sa atin? No? Mga building na walang laman. No? Yun po ang nasasaad sa kasunduan. At kung totoo nga po, no, kung totoo po na U.S. military presence will lead to modernization, we should now be a superpower after 44 years of the bases and 15 years of the VFA. Ano po ang nangyari? Bakit wala po yung sinasabing modernization? Binabanggit po kanina yung pag-store, no, yung paglalagay ng material. Gusto natin pong banggitin yung definition ng U.S. Department of Defense Military Dictionary. What do they mean by material? It means all items, including ships, tanks, self-propelled weapons, we presume missiles, aircraft, etc., and related spares, repair parts, and support equipment, excluding real estate, real property, installations, and utilities, necessary to equip, operate, maintain, and support military activities without distinction as to its application for administrative or combat purposes. So, ipaparada po sa atin dito, mga barko, mga tangke, mga sasakyang pandigma. Kasama po yon sa malawak na definisyon ng material na pwedeng i-preposition dito sa ating bayan. Next. Humanitarian assistance and disaster response. Ito raw yung maaari nating makuhang benepisyo. Gusto natin pong banggitin na nung panahon ng Yolanda, marami pong mga bansa ang nagbigay ng humanitarian assistance, disaster response sa atin. Pero Amerika lang po ang humihingi ng isang military agreement kapalit ng pagbibigay ng humanitarian assistance at disaster response. Tingin po natin, hindi kinakailangan. No? Hindi kinakailangan. Kung tutulong talaga, tutulong, pwede naman pong gawin yan ng mga civilian na ahensya without any military agreement in exchange for the humanitarian assistance. Next. Doon po sa pagiging practical, no? Nabanggit na nga po na unconstitutional, unnecessary, and hindi beneficial itong EDCA. Kaya hindi rin po maituturing na practical para sa ating mga kababayan, para sa ating gobyerno. It is grossly disadvantageous. Wala na nga po tayong malinaw na napapala, libre pa po nating ipapagamit ang ating buong bansa at mga pasilidad. Pati po yung tubig at kuryente, tax-free po natin yang ipapagamit sa mga Amerikanong sundalo. Ang magbabayad po ng tax sa utilities, no, sa tubig, sa kuryente at iba pa, ay ang Philippine government, no, yung AFP. So, nasan po talaga yung pakinabang doon? Hindi po, kumbaga yung tanning ng EDCA, maaring maging mas mahaba pa sa 1947 Military Bases Agreement. Originally, it was 99 years, pero ito'y na-terminate noong 1991. Dahil nga po, after 10 years, in effect na po itong agreement na to indefinitely. Kaya po, ang aming pong panawagan nga po sa Senado at natutuwa kami na iginigiit ng Senado ang kanyang poder sa usaping ito. At panahon na po talaga para panindigan po natin yung pambansang soberanya natin at pambansang interes at wag po tayong pumayag sa isang hindi makatarungan at grossly disadvantageous na kasunduan na tayo po ay talagang dehadong-dehado. Maraming salamat po.
Thank you, Mr. Renato Reyes. And finally, Representative Nery Colmenares.
Maraming salamat po, Madam Chair. Good afternoon sa members ng Senate. I will delve on certain issues na lang po, Madam Chair. EDCA is an agreement pertaining to the entry of foreign troops, bases, or facilities. The Constitution, under Article 18, Section 25, requires three things. One, it should be concluded in the form of a treaty. 2, it should be submitted to the Senate for concurrence in its ratification. And 3, that treaty should grant Congress the discretion and the opportunity to decide whether or not to call for a referendum and consult the Filipino people to approve or disapprove the same. Because of the insistence of the President to consider this as a mere executive agreement, he therefore violated the Constitution and the requirements of the Constitution. So in that sense, Madam Chair, I agree with the various resource speakers who said that, in fact, indeed, it should not be considered constitutional. But other than the constitutional requirements, Madam Chair, EDCA has dire and serious implications on Philippine sovereignty that requires the President, at the very least, the courtesy of asking or consulting the Senate and Congress before he commits the Philippines to the gross surrender of its sovereignty. 1, Madam Chair, it provides for basing of foreign troops. The term is prepositioning of foreign troops, prepositioning of war material, but it's actually basing. Whether or not it's a base, let's grant without even agreeing with the executive, it's not a permanent base. But the Constitution does not require that it be a permanent base. The basing of foreign troops and weapons is compounded by the provision under Article 3, Paragraph 1 of EDCA, which says that this can be deployed by the United States at any time. They have, in fact, the unencumbered right to remove this war material and deploy these troops. This transforms, Madam Chair, the Philippines into a launching pad to attack enemies of the United States. And the United States has a lot of enemies, Madam Chair. So now we will be embroiled in a war not of our own making. Doesn't this pose a danger to the Filipino people? We will be considered legitimate targets of the enemies of the United States because these troops and these weapons were previously based in the Philippines before they were deployed in Ukraine or in Syria or wherever the United States wishes to launch its war. This, we believe, should at least, the EDCA should at least grant the Senate the opportunity to discuss the ramification of this endangerment of Filipino people. Second, EDCA provides control over the United States, despite the statements of the executive that the control resides with the Philippines. The fact is, the provisions in EDCA provides virtual control on the part of the United States. For example, Madam Chair, it provides that all rights and authorities shall reside with the United States in the agreed location, including the taking of the appropriate measures for the defense and protection of their agreed locations and their personnel. This means that the United States have control, and in fact they can act if they feel that the defense of the agreed locations or their personnel is being threatened. They can take measures, Madam Chair, to meet such a supposed threat. Can the Philippines or does the Philippines have to approve these measures, Madam Chair? No. In fact, EDCA provides in Article 4, Paragraph 1, that the U.S. will coordinate, but the fact that they are allowed to take these appropriate measures to defend their agreed location means that they are the decisive factor here. 2, they have unimpeded access to the agreed locations. Tingin namin, hindi pwedeng mag-checkpoint dito ang Philippine government. I-inspect mo ang pumapasok na mga weaponry. No. The United States clearly stated in EDCA, unimpeded ang access namin sa agreed locations. In fact, unimpeded yung access namin in the deployment, unencumbered rights in the deployment. Ang Pilipinas po ba may unimpeded access? No. In fact, impeded ang access ng Pilipinas sa agreed locations because they have to contend with operational safety and security requirements of the U.S. And only the U.S. will say, you cannot visit, you cannot access the agreed locations because operational safety and defense requirements or safety requirements does not allow such access. So, whereas sila may unimpeded access, tayo naman ay meron. May control ba sila sa mga buildings? Klaro po yan sa Article 5, Paragraph 2. They control the buildings, they control the facilities. And, well, they can turn over these buildings and facilities someday, sometime, somehow, when they no longer require it. Can you imagine, Madam Chair, a contractual obligation where the condition is practically and absolutely dependent on one party? Kung kailan ko sasabihin hindi ko na kailangan, tsaka nyo lang makuha ang mga buildings and facilities na yan. So, despite the protestation of the Solicitor General that we own it, we control it, practically the EDCA, Madam Chair, disallows us or divorces us from any of this control. And lastly, Madam Chair, it allows for very many onerous provisions. The Senate must at least be, or Congress must at least be consulted whether na tama ba ang mamamayang Pilipino nagbabayad ng mataas na presyo ng kuryente, tubig, lahat ng utilities. The rich and powerful United States is exempted from paying taxes and charges and fees for their use of electricity, water, and other public utilities. Tama ba na i-impose natin, bigyan natin sila ng telecommunication system, free of charge ang use of radio spectrum? Tama ba na pag pumasok ang Amerikano dito, exempted sila from visa requirements? The regulatory tool of a government to process the entry of foreigners in the country is lost. That's why if you ask the Philippine government how many U.S. troops are here in the Philippines, they wouldn't know. Because there is no regulatory tool such as the visa. But the VFA-2, on the other hand, says that the U.S. Embassy has the right to deny a Filipino soldier entering the U.S. Is that not onerous? VFA-1, Madam Chair, which applies to EDCA, pag ang Amerikano ay accused of a crime, the U.S. automatically gets the custody of the accused upon their request. That's a mandatory provision, Madam Chair, another onerous provision. Is it really a request? How can it be a request if the word is shall? That's not a request, that's an order, in fact, that the U.S. turn over custody of an American soldier accused of a crime to the United States upon their request. VFA-2, on the other hand, says, if a Filipino soldier commits a crime in the U.S., well, they will ask the relevant agencies if they can waive custody in favor of the Philippine government. Marami pa pong onerous provisions na discuss ng iba kong kasama. But in the end, this violates the constitutional requirement of checks and balance. That is the purpose of this constitutional provision. There must be checks and balance so that the executive cannot sell out Philippine sovereignty and independence without at least consulting with either the Congress or the Filipino people. And I really hope that the Senate will make it a point to assert its constitutional prerogative under the Constitution and the mandate given by the Filipino people. Maraming salamat po, Madam Chair.
We in the Foreign Relations Committee express profound gratitude for the participation of our distinguished panel on both sides this afternoon. We have said at the start of these proceedings that the Supreme Court has ruled the Senate has no power to compel the President to submit a Senate or international document or agreement to the Senate for concurrence. So we cannot possibly order the President to send over the EDCA to us for our concurrence in the ratification. But what we can do is we shall express, since after all the Constitution divides the foreign policy power between the executive and the legislative branches, we shall issue a sense of the Senate resolution so that we can summarize the views and the attitudes that we have heard from today. Thank you very much. I will now hold my press conference here. Will you come forward, please? Please stay. Okay.
Another thing I wanted to raise with you was this is about the Bangsamoro.
Yeah.
It seems that my hearings are in fact premature.